Fantas, let me try to get at the questions that you've been asked in a different way. Let's say that I theoretically agree with you that under Guerrero-Lasprilla, mixed questions, including of this sort, would be subject to judicial review. Wouldn't you say, and I guess I'd push back a little bit on your characterization of Wilkinson's claims in particular below as being of that variety? Because, I looked at the record, his claims, he claimed that the immigration judge wrongly speculated about the care and support the child would receive if the petitioner was removed. They all read like weighing ones. He found while Wilkinson does provide emotional support, removing him would result in minimal emotional hardship because his son clearly has lived without Wilkinson's daily presence for most of his life because the mother had primary custody. So doesn't it seem like you're just seeking, or that your client was seeking, a reweighing of those facts, and so that under Patel they really would be not subject to review?
So all of the specific factual points that you pointed to, I agree with you. Those would be unreviewable.
Okay.
But what would be reviewable is the ultimate determination of whether that satisfies the statutory standard. And it is often the case, for example, that when you're potentially challenging the weighing of various factors and facts, an agency or a court of appeals can't just supplant its view of the evidence for that of the agency, but still the ultimate question of whether those facts satisfy the standard remain a question of law.
But it seems to me, I've looked some of these cases and the Sixth Circuit sides with you, but when it reviews these cases, it says that a lot of these claims about, well, you just didn't understand the strength of the emotional bond, or you didn't accurately predict what life would be like for my child if I were deported or removed, or my spouse. What the court says is those kinds of things are factual. And I guess that's where I'm stuck, because even if I accept your argument as flowing from Guerrero-Lasprilla, it's hard for me to see, looking at these cases, very many that aren't essentially factual challenges.
Well, Your Honor, I agree with you that all of those things you just pointed to that you cited from the Sixth Circuit cases, those are unreviewable. And kind of weeding out unreviewable findings and fact are things that appellate courts do all the time. They have to do so in every interlocutory appeal of a qualified immunity decision.
So would you accept then that there would probably be only a very narrow slice of cases that a ruling in your favor would make judicially reviewable, and including potentially even Wilkinson's own?
I think it depends on what the board does in any given case. I agree with Your Honor that if the IJ makes adverse factual findings, or if all the non-citizen is doing is challenging factual findings on appeal, those won't be viable claims. But what would be reviewable is the ultimate determination of whether those facts satisfy the standard. And here, I'll just point out briefly, Your Honor, that I think the Third Circuit clearly understood Mr. Wilkinson's challenge as being one to that mixed question, because it said, and you can see this on page 3A of the petition appendix, that Mr. Wilkinson argues that the hardship his son faces is indeed exceptional. That's not reviewable because it's discretionary. The court did not say Mr. Wilkinson is challenging findings of fact, and under Patel, those findings of facts are unreviewable.
Do you agree?